Emergency, emergency. That's what the Trump DOJ is saying, why they need to seize your Social Security information immediately from the Social Security Department. The Trump DOJ regime filed on Friday an emergency application to the United States Supreme Court saying that we need to get access to the American people's private Social Security information immediately, and that a district court has blocked us from getting this information. That is unfair. They are unfairly interfering with the functions of the executive branch. Supreme Court, please give us this information right now. I know there's a lot of information and news going on, Harry. So I think it's important, though, to talk about this case because we talked about it months ago. Remember the organization, by the way, I interviewed their CEO, Democracy Forward, this legal group doing great work. They're representing the unions, the AFL-CIO, and other unions. These groups are saying that they have standing to file this lawsuit. They brought the lawsuit. Harry, it was filed in a district court in Maryland, I believe.
That's
and
right.
The federal judge in Maryland, basically for the time being issued an injunction blocking the Trump regime from accessing the Social Security information. There was some back and forth where the Trump regime people said, well, look, you're now going way too far. And the judge says, read my order carefully. I didn't specifically say that like legitimate people can't, just this DOJ thing getting access. I'm not okay with it. We need to know more. So Trump and the Trump DOJ filed an appeal to the Fourth Circuit Court of Appeal, which sits over the district court in Maryland. They ruled in favor. Ultimately, there was what's called an en banc panel, meaning the whole Circuit Court of Appeals. They ruled 9-6, affirming what the district court judge did, meaning pausing DOJ from accessing this information. Interestingly, the group of 6 that would have reversed what the district court judge saying. It wasn't so much that they disagreed in the concept of it all. They just said there hadn't been an injury yet to the people, which it's like, well, what? It's kind of putting a little bit too much faith that Elon Musk is going to handle the data in a nice way once they get access. The injury is going to be once they start using that data for nefarious means, and the setup of having Elon, even do this. And you know what the biggest tell, Harry, is why I think it almost proves to me that there is an imminent injury, although I doubt it can be used before the Supreme Court. Elon's about to leave, apparently. His time's, heading out. And they're so worried about this now while Elon is still there. And so I think they want to try to get it to Elon while he's still in this special advisor role, because I think my opinion, I think he wants to use it. There's some notable things as well in this petition to the Supreme Court where the Trump administration saying emergency, emergency. John Sauer, the Solicitor General, is referencing Watergate and arguing to the Supreme Court that DOJ should have access to Social Security data. It says, yet the district court instead viewed agency employees within DOJ's team as the equivalent of intruders who break into hotel rooms. Just an interesting thing, of all things, to bring up Watergate in this. Harry, can you break down what's going on? And, the Trump regime seems very good. They want your Social Security data. That's one of the takeaways. They want the Supreme Court to order it.
And they love emergencies, as you said. Let's start there. In the 16 years before these 100 days of the Trump administration, the administration cried emergency and went to the Supreme Court 8 times. So far in Trump 2, 13 times they've made this same kind of pitch. And at some point, courts are going to say, look, this is not an emergency. Now, as you say, I think you're right. There's something to this point that Sauer made, that people see Musk a little bit like a burglar. I see him that way. I mean, the fear and the reason that the district court judge and 9 out of 15 of the Fourth Circuit, as you say, it went to the entire court. First 2-1, they held for the district court, then 9-6, is once he gets it, the barn door is open, and we certainly know from news reports and other things that people have been coming in and saying, give me all your data. Here's my thumb drive. And when people have been saying no, they're getting fired. So, what this comes down to, it is this sort of kind of persnickety procedural, is there standing or not on the basis of, can you really say they've got an injury yet, or they're kind of scared of one? You don't have to actually have got an injury, but it really has to be imminent. That's what Wilkinson, Mr. Conservative, who we were so impressed when he went the other way in the Abrego Garcia case, and 5 others said, and the 9 said, I think it's close enough. And anecdotally, I feel it's close enough. These guys are up to no good with this information that's supposed to be private. The point is, sometimes there are legitimate reasons that a government can have this information, including prosecutors with good reason. And for that, that's the basis that the minority in the Fourth Circuit was saying, no injury yet, just the mere fact that it's possessed. They've got to do something unauthorized, like give it to the public or mess with it in the way that everybody thinks Musk is going to. So that's the sort of small point that brings it up to the Supreme Court. We'll see what the court does with it. But I do want to underscore, and I wonder how much patience the Supreme Court has for all this stuff. This is just an emergency happy crowd, and emergencies, they're a serious thing in the law. You really have to show that the sky is falling. And what are they saying here? Why is it that they can't just litigate this in the Fourth Circuit, and if they win, they'll get this information in a few weeks? The arguments are not really very strong there. We want Musk to have this stuff now. Okay, but he may be leaving. Okay, but you can still get it down the line. So I think a really important sub-theme here, maybe even the major one, is this whole emergency slap-happy attitude of the administration, and whether the courts are going to grow a little bit tired of that, because it's obviously their regular MO.
Let me read some portions of this application by the Trump regime to the Supreme Court. Here's what they're saying. They're saying, in addition, the order by the district court bases that interference on an unsupportable this is what Trump's arguing, to be clear, on an unsupportable application of the Privacy Act. So they're saying the district court federal judge who would not give DOJ access to your Social Security data, they're saying that there's no Privacy Act violation. Give it to Elon. Give it to Elon. And they're saying, why is the judge buying a Privacy Act argument, which authorizes employees to access records when employees need such access? They go, the standard, this is what Trump's arguing, the standard is clearly met here. Employees with Musk charged with modernizing government information systems and routing out fraud, waste, and abuse in data systems plainly need access to those systems.
Don't you feel better now, Ben, knowing why they need it?
They also go here. This case justifies the Supreme Court's intervention because the district court made glaring legal errors in the course of halting high priority functions in a key agency. High priority functions. That's what they're referring to here. To start, respondents, 2 labor unions and advocacy organizations lack standing on 2 independent grounds. They cannot claim that they have any concrete injury from having particular agency employees, members of the SSA DOJ team, access their information when those employees are subject to the same legal and ethical obligations against further dissemination that bind all agency employees. So, Harry, they're basically going with, whereas when Trump was not in office, they try to make every argument why they had standing underneath the sun, state standing, in order to stop people from getting student debt relief and things like that. But now they're saying these people, what's your real injury here? There's nothing to worry about. What do you make of it? I'll give you the last one.
I mean, look, it's an arcane legal issue, but I think you can summarize it like this. Lighten up. why are you so worried about Elon Musk? I mean, that's really what's going on. And you and I could talk for an hour about why everyone's so worried about Elon Musk. And that's really what it reduces to in terms of this emergency setting. Fine, you could go back and, litigate it with what they're not doing anything yet, etc. But what they're saying is we can't even wait that long. It's high priority. That's, you really put your finger on what the right word is there. Why exactly? Or what's the irreparable injury? Well, it's high priority. And that's why you've got to right now tell the district court to, all the district court has done here, mind you, and this comes up again and again, has said, Boasberg's another good example. While I figure this out, let's just everyone not do anything more here. Let's not disseminate, etc. Don't give it to DOJ yet. That's all the court has said, and the that's all. Yeah, that's all the court has said, and now they're coming forward and saying that's a terrible emergency. We right now need to be able to give it up, and then we'll litigate. Of course, if you give it up and you litigate and they do anything untoward with it to violate the Privacy Act, you're screwed. Privacy Act gives some money for those violations, but people here are justifiably worried that the government is going to take their social security information, which we're told again and again and again, never give that away. That's how identity theft happens, etc. Now it's how much do you trust Elon Musk? Because that's what is the basic notion that the courts have approved and now comes up to the Supreme Court on this emergency basis.
Right. So Donald Trump, Elon Musk, they say fraud. Right. We all know that they've lied over and how do you know they're lying? They open up their mouth. Yeah. And they're also saying, gimme right now. Gimme. I need like rabid dog. Gimme. Need it. And all the district court saying is chill. I don't know one way I'm not saying that you lose. I'm not saying that you win. I'm saying this concerns me, what Musk and you are doing. I've got enough information to be worried. I can't unring the bell if you are doing malicious things I'm looking at you people watching, I'm looking at you with their social security. So let's just chill. And then what's going on in the Supreme Court?
Exactly right.
We need it. And we need it right now. And what Harry's saying though is like, what's the emergency? And again, Harry and I can talk hours about this. This is the kind of sociopathic mindset though, in my view, like of an abuser, which is like, I want it because it's mine. I'm the executive branch. Give it to me. I get what I want. It'll be interesting to see what this Supreme Court, does here, because, when you apply rigid and technical legal definitions and you go, well, an injury is like, when someone's car gets hit, and you get an injury, an injury is when, you actually, there's a physical hurt. So once they give the documents over, and then if it's used, then your injury, that's the issue that the Trump DOJs, and we can talk about it. We could geek out. We have other videos we got to geek out on though that people want to see. So subscribe to Talking Feds Substack, Talking Feds YouTube, and the Talking Feds podcast, wherever you get your news. Talking Feds. That's where I get my legal news. Thanks, Harry.
Thank you, Ben.
Can't get enough Meidas? Check out the Meidas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MeidasPlus.com.